Top of the morning, Dan and Amy. Janus v. Afscme, an Illinois case. Mark Janus, former state employee, decided by the Supreme Court in 2018 and overturning a 1977 case, Abood, that allowed such union fees, the forcible collection of so-called fair share union fees. That was overturned by Afscme, hailed by many, myself included, as a real seminal moment in not just jurisprudence on labor and unions, but also a seminal moment in terms of the politics and the political strength of public sector unions. You thought there would see attrition over the years that would really defang and minimize the dominance of public sector unions in particular states like Illinois. Is that really happening? I don't think it's happening on the pace that was hoped, and in part because the unions have been rather intransigent in giving up those fair share fees and really in complying with the spirit as well as the letter of the law. And so here we are litigating the matter again. National Right to Work is doing so on behalf of public school teachers in both Chicago and New Jersey, trying to extricate themselves from their unions, their respective teachers' unions. And for more on this, we're pleased to be joined by Mark Mix, president of National Right to Work Foundation. Mark, thanks for joining us. Appreciate it.
Dan, good to be on with you again, and thanks for the opportunity. 3 years ago yesterday, the U.S. Supreme Court ruled that it was a violation of your First Amendment free speech rights to compel you to pay dues or fees to a union in order to work for your government. And yet today, we are continuing to fight that, even though the court ruled in their majority opinion that no worker could be fired, and secondly, that every worker had to give an affirmative waiver of their First Amendment rights. We've got another case going up to the U.S. Supreme Court asking them to hear the case of 2 Chicago teachers and 2 New Jersey teachers who were prohibited from exercising these rights by these so-called escape periods that you indicate the unions have put up these kind of hurdles. They're not necessarily roadblocks, but they're definitely hurdles, and they're not interested in letting workers out, that's for sure.
Well, what can you tell us about the 2 Chicago public school educators and what was their breaking point and why they wanted to separate from the union?
Yeah, I mean, that's a great question. As it relates to the 2 Chicago teachers, they were unaware of their Janus rights going into 2019, and in the fall they heard rumors that the Chicago Teachers Union was going to call a strike in October, so they started doing some research. They found out about the Janus decision. They alerted the union they wanted to withdraw because what they wanted to do was continue teaching. They didn't want to go out on strike with Mr. Sharkey and the rest of them there, and they wanted to stay in the classroom. Well, they wrote their letters. They did everything right. The union ignored them until November after all of the hubbub had gone by and said that they couldn't get out for another year. And so it was going to be until September of 2020 that they could actually exercise their rights, even though the union didn't have the waiver and the teachers requested the opportunity to get out. So they're 2 from Chicago. The 2 in New Jersey were more aware of Janus. In fact, it was July of 2018 where they wrote their letter saying get out, and they didn't know it. But Jersey legislature, in order to limit the impact of Janus, mentioned in the intro, they passed a piece of legislation that said there would be a 10-day window period, escape period for these teachers, and they passed that in May, knowing that Janus was likely going to be the law of the land in June. And so when they did their process, they said, oh, well, you missed your 10-day window, and you can't get out, and you have to continue paying dues. So lots of litigation, but the principle is still in place, the First Amendment, and we are winning, Dan. It's certainly not as fast as we had hoped that the workers would exercise these rights and know about them, but they're still to be done.
And so the idea is that these contrived escape clauses, this is something that you want the court to weigh in on as well and declare inconsistent with Janus.
That's correct. And there's been several cases out there on this, and these are the kind of the first 2 to get up there that are specifically about the escape period. There's been other cases that have been petitioned to the court that have been denied that were about a whole host of matters, and there's lots of litigation on Janus now. And there are victories, Dan. There are literally thousands and thousands and thousands of workers have exercised their rights. Hundreds of thousands of workers actually have won the opportunity to exercise their rights. It's not enough, and the First Amendment needs to be enforced here, but there's always work to be done. And to your point, union officials are not giving up easily on this.
And I know a lot of teachers who are very upset that because they wanted in-person learning, they wanted to stop the hybrid, and that they are dropping their union. Has anybody else reached out to you?
Yeah, currently we have about 35 cases going, active cases that are Janus related, and there are other groups. Liberty Justice Center has cases, the Freedom Foundation out on the West Coast, and the Mackinac Center, and a few other organizations have got cases. There's about 96 active cases as of the beginning of June there that we're currently working their way through the process. And so there's lots going on. There's lots of information out there. It is problematic because teacher unions are certainly not going to let their members know, and school boards are not going to let their teachers know what their rights are vis-a-vis this union coercion.
Besides the escape clause, as you described, what are some of the other hurdles that the unions are throwing up to try to, East Germany style, keep people in?
Well, just, kind of the information blackout, Dan, and then the escape periods, and then the idea that they just ignore teachers. Those are the types of things. I mean, there's several different iterations of cases, the escape period being one. There's clawback cases where we're trying to get money back for those workers. We continue to litigate that on behalf of Mark Janus, and the Supreme Court decided that they were going to do it prospectively, not retrospectively, even though under black letter law, when you decide a constitutional question, it's as if that always existed, but the Supreme Court wasn't willing to jump back into that pool and give relief to those workers that were exercising their rights back to the statute of limitations. So, the First Amendment applied starting June 27, 2018. It didn't apply anything behind that, but there's still litigation on that front, and there's still work to do for sure.
Yeah, in Illinois, there's a ballot question that is passed, will be on the November 2022 ballot. That's really interesting. What the General Assembly here did, perhaps but this is what it says. Employers shall have the fundamental right to organize and to bargain collectively through representatives of their own choosing for the purpose of negotiating wages, hours, working conditions, and to protect their economic welfare and safety at work. No law shall be passed that interferes with, negates, or diminishes the right of employees to organize and bargain collectively. So, first of all, throwing in economic welfare, that's the kitchen sink language, number one. Yeah. And number two, no law shall diminish the right of employees, which is unnecessary. It's sort of redundant, but it almost speaks to a desire that this be enforced over Supreme Court jurisprudence when it comes to these matters.
Yeah, absolutely. In a way, it's kind of flattering, Dan. We passed 5 new right-to-work laws in the last 10 years, including in Michigan and Wisconsin and Indiana, surrounding Illinois. And what they're actually trying to do, what all that mumbo-jumbo that you just read means, is they are going to prohibit the legislature from ever considering a right-to-work law in the state of Illinois. That's what they want to do, and that's what they're scared of. And interestingly enough, it was Bob King, the former president of the United Auto Workers Union, who's in this case is free on retirement. The last 2 presidents are in jail at this point, but Bob King is still out there in the public domain. And once we passed the law in Indiana, he put a ballot on the initiative on the ballot in Michigan to do exactly what you're trying to do in Illinois, and it failed by 16 points, and about 3 weeks later, Michigan became a right-to-work state. So I don't know if that'll happen in Illinois, but that's what it's about. It's about forcing workers to pay union dues to keep their jobs in perpetuity.
And so as, these cases wind their way through the courts, what is your now revised perspective on the impact Janus is going to have, say, in the next 5 or 10 years? States that are dominated by the public sector unions and destroyed by them, like Illinois, a lot of people recognize until you can rebalance the balance of power away from the public sector unions, you're going to continue to have a state that is not a pleasant place to be, like Illinois is not, that is unlivable at an exorbitant price. And so, give us your recalibration on the impact Janus will have on the power of public sector unions in this country.
Well, first and foremost, workers have that First Amendment right. Exercising it's the next big step. I think the impact will be dramatic. It will come to be that workers will understand that they have the right. And frankly, I think the unions will be the ones that change it, because ultimately, I believe that they have to see that voluntary unionism is the only recipe for their continued survival. The fact that they have to force people into these union collectives and then, bill the taxpayers for it in an exorbitant way, like in California, Illinois, New Jersey, New York, etc., that will come back. It just takes time. And Dan, you've been at this a long time, I know. Amy, you've been talking about it a long time. I've been at it a long time, and there's progress being made. Oftentimes it's slow. It's not as dramatic as we'd like, but it's there, and we can continue to work on it. And this experiment, the American way is that individual rights will prevail, and I believe that, and we have to believe that as we continue to go. Our 21 attorneys are working hard for employees across the country that want to exercise these rights, and you never know. Janus was kind of a lightning strike, as was the passage of the Right right to work law in Indiana and in Michigan and Wisconsin and Kentucky and West Virginia over the last 10 years. So we just got to keep fighting at it, keep informing people of their rights, and provide the services they need to get out. That's what we'll do.
He is Mark Mix, President, National Right to Work Foundation. Mark, good luck in court.
Thanks, Dan.
Thank you. Yep, thanks. And he joined us on our turnkey.pro answer line.
It's news, opinion, insight. This is Chicago's Morning Answer on AM 560. The Answer.